You just got pulled over. Broken taillight. Maybe you were going a few miles over the limit. Nothing serious. The officer takes your license and walks back to his car. You think he's writing a ticket. He's not. He's running your name through a federal database that has access to records from law enforcement agencies across the entire country. And in the next 60 seconds, that database is going to tell him things about you that you may not even remember. And here's the part that should keep you up at night. In 2016, the Supreme Court of the United States ruled that even if that stop was completely illegal, even if the officer had no legal right to pull you over, anything he finds after running your name can still be used against you in court. Stay with me, because by the end of this video, you're going to understand exactly how this works, and you're going to want to share it. Let's set the scene. It's a Tuesday afternoon. You're driving home from work. You're not drunk, you're not carrying anything illegal, you haven't done anything wrong today. Then the lights come on. Maybe it's a tail light. Maybe you rolled through a stop sign. Maybe the officer just ran your plate and noticed your registration sticker is 2 months expired. You pull over, you breathe. You grab your license and registration. Standard stuff. You've been through this before. But here's what you don't see. The moment that officer walks back to his patrol car, he types your name into a system called the NCIC, the National Crime Information Center. It's a federal database run by the FBI, connected to law enforcement agencies in all 50 states, available 24 hours a day, 7 days a week. In seconds, not minutes, seconds, that system tells the officer whether your license is valid, whether your vehicle has any flags, and most importantly, whether there are any outstanding warrants attached to your name. During any lawful traffic stop in all 50 states, running your name through federal and state databases is completely legal and routine, and you have no right to know that search is happening. You have no right to stop it. Now, most of the time, nothing comes back. The officer writes your ticket, you sign it, you drive away. But sometimes, something does come back. And when it does, the rules of that traffic stop change completely. So what exactly does the officer see when he runs your name? Most people assume it's just your driver's license info. Name, address, maybe whether you have prior DUIs. It's a lot more than that. The NCIC pulls your license status, your vehicle registration, any stolen vehicle flags. In some jurisdictions, sex offender registry status. And the big one, the wanted persons file. That file contains records on individuals for whom a federal warrant is outstanding, or a felony or misdemeanor warrant has been issued by any law enforcement agency in the country. But here's the thing most people don't understand. When people hear warrant, they picture something serious, a fugitive, someone wanted for robbery or assault. In reality, the most common type of warrant showing up in that system isn't for a violent crime. It's called a bench warrant. A bench warrant is issued by a judge, not for committing a new crime, but for something like failing to appear in court, missing a hearing, not paying a fine, letting a traffic ticket go unresolved for too long. Think about that for a second. You got a speeding ticket 5 years ago. Life got busy. You meant to deal with it. You forgot. Maybe you even moved and the notices stopped coming to your address. That ticket could have turned into a bench warrant, and that bench warrant is sitting in a database right now, waiting for the next time a police officer types your name into a computer. And the worst part? In most states, you have no way of knowing it's there until the moment it surfaces during a stop. Millions of people are walking around with one right now, without knowing it. But knowing the warrant exists is only half the problem. The other half, the part the Supreme Court weighed in on, is what happens after the officer finds it. And that's where this story gets a lot darker. December 2006, South Salt Lake City, Utah. A narcotics detective named Douglas Fackrell was watching a house, anonymous tip about drug activity. One afternoon, a man named Edward Streif walked out and headed down the street. Fackrell stopped him, asked for his ID, called it in to dispatch. And dispatch came back with something unexpected. Edward Streif had an outstanding warrant. Not for drugs, not for violence. for a traffic violation. Under that warrant, Fackrell arrested Streiff, and when he searched him incident to that arrest, standard procedure after any lawful arrest, he found methamphetamine and drug paraphernalia. Streiff was charged. He moved to suppress the evidence, and his argument was straightforward. The stop was illegal. You had no reasonable suspicion to detain me. Everything you found came from that illegal stop. It should all be thrown out. The way to the Supreme Court of the United States, and here's the part that matters. The state of Utah, the prosecution, actually conceded that Fackrell had no reasonable suspicion to stop Streiff. They admitted the stop was unconstitutional, but they argued the evidence should still be admissible. Because once Fackrell discovered that pre-existing warrant, a warrant that had nothing to do with the stop, that existed before any of this happened, that warrant broke the chain between the illegal stop and the evidence found. In June 2016, the Supreme Court agreed, 5-3. Justice Clarence Thomas wrote the majority opinion. The evidence was admissible. The warrant was an intervening circumstance that sufficiently separated the illegal stop from the search that followed. Edward Streiff was convicted on the basis of a search that began with a stop the government admitted was unconstitutional. But it was the dissent, the minority opinion, that said out loud what this ruling actually means for ordinary Americans. Justice Sonia Sotomayor wrote, "This case allows the police to stop you on the street, demand your identification, and check it for outstanding traffic warrants, even if you are doing nothing wrong." Read that again. Even if you are doing nothing wrong. What the Streiff decision created, in practice, is a system where an illegal stop can be retroactively justified by whatever the database returns. If you have a warrant, any warrant, even one you forgot about, the officer gets to keep everything he finds. The illegal stop disappears. Legally. The system wasn't supposed to work this way, but after June 20th, 2016, it does. You just learned that a traffic warrant you forgot about can turn an illegal police stop into a legal arrest and make every piece of evidence they find admissible in court. And we're not even close to done. Coming up, how many Americans are actually carrying one of these warrants right now without knowing it? Which states require officers to arrest you on the spot the moment one shows up? And the one thing you can do before your next traffic stop that most people never think about. If this is the kind of thing you want to know, the laws that actually affect your life that nobody tells you about until it's too late, hit that subscribe button right now. Subscribe to Law Drop, like this video, and turn on notifications so you never miss what's coming next. Let's keep going. So let's talk about scale, because the natural reaction to everything you just heard is, that's terrible, but it probably doesn't apply to me. I don't have any warrants. But here's the question most people can't actually answer with confidence. Are you sure? Researchers at the Data Collaborative for Justice at John Jay College estimated that in 2016, there were at least 7.8 million outstanding warrants across the United States, and that number excludes warrants from municipal courts entirely. The actual number is almost certainly higher. A separate investigation of 27 states found over 5.7 million open arrest warrants, over 1 million of them for minor offenses, unpaid parking tickets, missed traffic hearings, things most people wouldn't even call crimes. Not crimes, administrative failures. You get a ticket, you forget. The court sends a notice to an old address, a bench warrant gets issued. It sits in a database indefinitely. You're never notified. And the next time an officer runs your name, it surfaces. And here's where it gets worse, depending on where you live. In most states, officers have discretion. They can let you go with a warning to resolve it. But in some states, like Missouri and Kentucky, that discretion doesn't exist. When a bench warrant comes back, they are legally required to arrest you, on the spot, regardless of how long ago the original offense was. Louisville, Kentucky. Arrests based solely on bench warrants increased 73% between 2006 and 2019. By 2017, 46,000 active bench warrants in a single city. People pulled over for a broken taillight, arrested, because a database remembered something they forgot. And once that arrest happens, everything the officer finds is admissible. That's Utah versus Strieff. That's the law right now. That forgotten ticket isn't just an inconvenience, it's a door. Now let's talk about something the data makes impossible to ignore. Because the system we've been describing, where a routine traffic stop triggers a database search, and that search can escalate into an arrest, doesn't affect all Americans equally. Not even close. Researchers at Stanford University analyzed nearly 100 million traffic stop records from agencies across the country. What they found is called the Veil of Darkness test. During the day, an officer can see a driver's race before deciding whether to pull them over. After dark, that's much harder. So the researchers asked, are the same drivers being stopped at the same rates, day and night? The answer was no. Black drivers were less likely to be stopped after sunset, when their race was harder to see. The pattern held across dozens of jurisdictions. That gap is evidence that race is influencing who gets pulled over in the first place. And it's not just who gets stopped, it's what happens next. The state of Illinois requires law enforcement agencies to report traffic stop data. The results, published in 2024, are stark. Statewide, police stop black drivers at 1.7 times the rate of white drivers. In Springfield and Peoria, that number jumps to over 5 times. Here's where the database search connects directly to this. If you're being stopped 5 times more often, and every stop automatically triggers a name search, you're also being run through that database 5 times more often, which means any bench warrant you have is 5 times more likely to surface. And the Illinois data shows something else. More than 97% of stops of black drivers statewide found no contraband whatsoever. Read that again. 97% found nothing. The ACLU of Illinois called many of these stops fishing expeditions, initiated not because of observed violations, but based on something else entirely. And every one of those fishing expeditions includes a warrant check, a moment where a forgotten ticket could change everything. This isn't about politics. This is about how two systems, pretextual stops and automatic database searches, interact, and who ends up most exposed to that interaction. If you get stopped more, your name gets run more. Any warrant you have, no matter how minor, has more chances to surface. Understanding this doesn't require picking a side. It just requires looking at the numbers. So now you understand the system, but here's what most people miss. What could actually matter the next time you're in that driver's seat? There are limits to what a police officer can legally do during a traffic stop. The Supreme Court spelled them out in Rodriguez versus United States, 2015. A traffic stop has a mission. Check your license, verify your registration, issue a citation. Checking for outstanding warrants is a routine part of that mission. That part is always legal. But the stop cannot be extended beyond what that mission requires. And running a full criminal history, past arrests, prior convictions, is a different question. Courts across the country have disagreed on whether that's permitted. Here's what matters practically. 1. You cannot stop the warrant check. It happens automatically the moment your name is run. No opt-out. 2. In most states, you are not required to answer questions unrelated to the stop. You can say, "I'd prefer not to answer questions." In stop and identify states, identification rules are stricter. Check your state laws. This video can't tell you what to do in your specific situation. Always consult a licensed attorney. 3. You cannot refuse to show your driver's license and registration. Required in all 50 states. Proof of insurance is required in most states. 4. If an officer asks to search your vehicle, you can decline. In most states, declining consent is not probable cause. It is a right. The most useful thing you can do right now, check whether you have any outstanding warrants. Most states have online court portals where you can search your own name, and it takes 5 minutes. Search every state and county you've lived in, because state portals often miss municipal warrants. In most states, resolving a bench warrant before it finds you is far simpler than dealing with it on the side of the road. The warrant doesn't care that you forgot about it. Everything you've learned so far applies broadly across the United States, but the degree to which you're exposed to this system, how much protection you have, how little discretion an officer has, what happens the moment a warrant surfaces, depends heavily on which state you're in when that patrol car pulls up behind you. And the gap between states is wider than most people realize. Let's start with the states that have made things worse for drivers. Missouri and Kentucky sit at the top of that list, not because stops are more common, but because of what happens after a warrant surfaces. In both states, officers have no discretion when a bench warrant appears during a stop. State law requires an immediate arrest. It doesn't matter if the warrant is for an unpaid parking fine from 4 years ago. It doesn't matter if you've been living clean since. The moment that warrant appears on the officer's screen, you are going to jail. That's what produced the Louisville numbers you saw earlier. 46,000 active bench warrants, arrests up 73% over 13 years. Not because crime increased, but because the system was designed to leave no room for judgment. Texas and Florida round out the high exposure tier for different reasons. Both are stop and identify states with broad database access during stops and no meaningful state-level limits on pretextual stops. In Florida alone, the state maintains its own criminal information database, the FCIC, which officers can access alongside the federal NCIC during a stop. Now let's look at the states moving in the other direction. Virginia made a significant change in March 2021. A new law, Senate Bill 5029, converted more than a dozen minor traffic infractions from primary to secondary offenses. What that means in practice, an officer in Virginia can no longer pull you over solely because of a broken taillight, tinted windows, an object hanging from your rearview mirror, or the smell of marijuana coming from your car, or the smell of marijuana coming from your car. Those infractions are still illegal, they just can't be the standalone reason for a stop. California has gone further in some jurisdictions. San Francisco ended pretextual traffic stops for 9 categories of minor violations entirely. A 2022 state law added additional restrictions on equipment violation stops. And California is not a stop and identify state. Outside of a vehicle stop, you are not required to give your name to an officer who approaches you on the street. Now, what does this mean if you travel? This is where it gets complicated for a lot of Americans. The protections Virginia put in place in 2021 only apply in Virginia. The moment you cross into North Carolina, Tennessee, or West Virginia, you're operating under a completely different set of rules. And your outstanding bench warrant, the one sitting in a database somewhere, travels everywhere. It doesn't respect state lines. It doesn't expire when you cross a border. In many states, bench warrants for minor offenses have no expiration date at all, though this varies by jurisdiction. Check your state laws. Here's the practical reality for anyone driving through multiple states, which is most of America. You may benefit from Virginia's protections on Monday, drive through Tennessee on Tuesday, cross into Kentucky on Wednesday. Each state, different rules, same warrant, same database. The system isn't uniform. The exposure isn't uniform, but the database is. And that's the part most people driving across state lines never think about, until the lights come on. We've covered a lot of ground. The database, the warrant, the Supreme Court decision, the states where officers have no choice. But I saved the most important part for last, because everything you've heard so far assumes one thing, that you know whether you have an outstanding warrant. Most people don't. Think about the timeline. You got a traffic citation, maybe 5 years ago, maybe 10. You moved. The address on your license was never updated. The court sent notices to an address that was yours 2 apartments ago. You never saw them. The court set a hearing date. You didn't appear because you never knew there was a hearing. The judge issued a bench warrant for failure to appear. That warrant was entered into a state database, and it has been sitting there, invisible to you, ever since. Now it's Tuesday afternoon. You're driving home from work. The lights come on, the officer walks back to his car, types your name, and in 60 seconds, a warrant you had no idea existed surfaces on his screen. In a state like Missouri or Kentucky, he has no choice. You're under arrest. Under Utah versus Strieff, anything he finds is admissible. For something that started with a citation you forgot. Justice Sotomayor understood exactly what this means for ordinary people. In her dissent, she didn't just address the legal technicalities, she addressed the human reality. She wrote that this ruling asks ordinary people to submit to the indignity of a stop and frisk based on nothing, and then says the Constitution offers them no remedy as long as a warrant, however minor, is waiting somewhere in a database. By legitimizing the conduct that produces this double indignity, the court tells everyone, white and black, guilty and innocent, that an officer can verify your compliance with the law at any moment. Justice Sonia Sotomayor, dissenting, Utah versus Strieff, 2016. That quote was written in 2016. The decision it responds to is still the law today. And the system it describes, traffic stops, database searches, bench warrants for forgotten tickets, processes millions of Americans every single year. Here's what you can do right now. Most states have online court portals where you can search your own name for outstanding warrants. It takes 5 minutes, it costs nothing. Search your county court website. Search your state court portal. If you've lived in multiple states, search each one. If something comes up, a bench warrant, an old citation, a missed hearing, depending on your state and the type of warrant, a criminal defense attorney may be able to resolve it before it becomes a problem on the side of the road. The warrant doesn't expire because you ignored it, but it can be resolved before it finds you. This video is for informational and entertainment purposes only and does not constitute legal advice. Laws vary by state and may have changed since this video was published. Always consult a licensed attorney for guidance on your specific situation. You got pulled over for a taillight. The officer ran your name, and a system you never knew existed, built around a database, a Supreme Court decision, and a bench warrant for something you forgot, decided what happened next. Now you know how it works. Think about someone you know, a family member, a friend, a coworker who moved twice in the last 5 years and hasn't thought about that old speeding ticket since the day they signed the citation. They don't know this system exists. They don't know their name is searchable. They don't know what a bench warrant is or how one gets issued without anyone ever telling you. They don't know that a Supreme Court decision from 2016 means a forgotten ticket can turn a routine stop into an arrest. You do now. Share this video with them, not because it's interesting, because it's information they need before they're sitting on the side of the road with the lights flashing behind them. That's what Law Drop is here for. The laws that affect your job, your money, your rights. The ones nobody explains until it's too late. If this video gave you something you didn't have before, hit that like button. It helps more people find this. Subscribe to Law Drop so you don't miss what's coming next. And turn on notifications, because we drop a new video every day. And some of them are going to surprise you even more than this one. One last thing. If this video surprised you, if you had no idea this system worked this way, drop the word warrant in the comments right now. Just that one word. It tells us this mattered to you, and it helps other people find this video when they need it most. Stay informed, check your state laws, and we'll see you in the next one. And speaking of systems most Americans don't know are working against them, in the next video, we're covering something that's going to reframe how you think about crime in this country. Every year, more money is stolen from American workers than from every robbery, every burglary, and every car theft in the United States, combined. It's not stolen at gunpoint, it's stolen with a paycheck. And in most states, the person doing it will never be charged with a crime. That's wage theft, and the numbers are going to shock you. That's next on Law Drop.